Well, you should be able to prepare a transfer on death for that one account, and basically both parties will have to sign that, and that shouldn't change through if one of you passes away. So you should be able to prepare one of those documents with both of your signatures on it, and then you probably you shouldn't have to fill out another one because it's really the same thing. Okay, who else do we have? Yes.
What about like on land or something? What's the difference or benefit would be to a right of survivorship or TOD, or what's the difference there?
Okay.
Good question.
Land is generally transferred. If you have a couple, my recommendation is to do transferring to that couple with the right of survivorship. So if any of you have any old deeds out there, there was a time in the 80s when that wasn't really an option. They had other options back then. You should get out your deed and make sure that you do have a right of survivorship if that's your intentions. The key about that is if one of you passes away and you have the right of survivorship, it's the same thing, the same consequence as a TOD. You don't have to go through probate, you don't have to wait for it. Basically, the surviving spouse files what's called a survivor affidavit, and they file it with the recorder's office, and then they have full access to that property. It's in their name. That's all they have to do. The same thing with a TOD. When you, let's say it's an individual or a couple, it doesn't matter. If you have an individual or a couple and that party passes away or the couple passes away, then it will automatically transfer to that other party that it's supposed to transfer to. All they have to do is file the survivorship affidavit, and it's automatically theirs, basically. So you're not going through probate. If you don't do that, if you have a couple spouses that do not have the right of survivorship, that property doesn't transfer in full to the other spouse. So basically, for instance, one situation where it would matter is if the person who passes away has a child which is not the other party's child. That child has an interest in that home now because they did not have the right of survivorship. So they basically have the heirs of the person who passed away have an interest in that home, usually a 50% interest. So then you're going through probate, it's a whole thing. It becomes, and actually we were dealing with some situations like that recently, so.
Yep.